Good morning, everyone. I hope you can hear me out there. Thank you for joining Craig Safety Technologies and Dysart Taylor Law Firm for this webinar, DOT Policies, Sword or Stone. I'm Terry Simmons, DOT Safety and Compliance Director for Craig Safety Technologies. My main function at Craig Safety is to help carriers understand compliance and safety and put that to work in their companies. Craig Safety offers a lot of services to carriers, such as monthly log audits and DOT mock audits, consulting, safety rating remediation, and safety management plans, just to name a few of the things that we do. Craig Safety's featured product is our unique software platform that allows any company to easily manage compliance, people, and assets, both for DOT and OSHA, and it has several other things that it will offer as well. Our software allows companies to focus on their businesses and not stress over being in compliance. As the Director of Safety and Compliance, I'm a huge advocate in the trucking industry for safety and for bringing knowledge and light to the trucking profession and professionals, which is why we wanted to share this webinar with you this morning. I'm very, very pleased to have John Wilcox as our speaker. We don't often get a chance to speak with a lawyer or to have him speak with us, so we're especially fortunate John agreed to come and speak to us as an industry expert about how policies can really make or break a carrier and how we can utilize them to protect our companies from unnecessary exposure to risk. John has a very impressive background, which I want to share with you before we actually get him talking here. So he is a shareholder director of the Kansas City, Missouri law firm of Dysart, Taylor, Cotter, McMonigal, and Montemore, PC. John is an experienced litigator with substantial experience in the areas of transportation and logistics, product liability, commercial disputes, employment, and criminal law. His transportation and logistics practice includes the representation of motor carriers, drivers, 3PLs, shippers, and manufacturers in wrongful death, serious personal injury, and cargo claims. He also assists clients with administrative and compliance issues. During his career, John has briefed and argued a number of cases before the Kansas Supreme Court and the Court of Appeals. John is a graduate of Missouri State University and the University of Kansas School of Law. He frequently speaks and writes on topics affecting the transportation industry. As far as his professional involvement, he's involved in the Transportation Lawyers Association and is currently the chair for the Logistics and E-Commerce Committee. He has been the representative at large for the Executive Committee. He's involved with the Council of Supply Chain Management for Professionals, also Defense Research Institute, the Kansas Motor Carriers Association, the Missouri Organization of Defense Lawyers, the American Bar, the Missouri Bar, in the Transportation Law Committee, and the Task Force the Task Force on the Future of the Profession in the Technology Subcommittee, Kansas Bar Association, the Johnson County Bar Association, the Kansas City Metropolitan Bar Association, and the Conference of Freight Council. He does numerous community activities, such as being on the board of the Notre Dame de Sion School of Kansas City, where he has done numerous activities such as Sports Booster Club. He was the treasurer, the Advancement Committee, the annual auction, the annual fund. He's been on the Rockhurst High School alumni. He is one of the Rockhurst Alumni Association members and has been on the board of governors for them. And he's also been involved with the Wildwood Education Center, being on the board of directors for them. John has had many publications out for the Transportation Lawyer publication and In Transit, and put out several articles for them. He's done many presentations for, again, the Transportation Lawyers Association, the Missouri Bar, the Cincinnati Insurance Companies. So he's well known for his presentations and publications. He practices law in the areas of arbitration and mediation, insurance, labor and employment, litigation, products liability, and transportation and logistics. He actually has honors in AV Preeminent Rating by Martindale Hubbard, the Missouri Bar Pro Bono Wall of Fame, 2011, and he was selected for inclusion in the Missouri and Kansas Super Lawyer list in 2014, and is on its rising star list in 2008. So we are fortunate and honored by his participation and presence today. A little housekeeping: we will be doing questions at the end, and you can type those in your chat feature online, and he'll be addressing those at the end of the presentation. So I'm going to thank you for joining us again, and I'm going to turn this over to John. Thanks.
Thanks, Carrie, for your kind introduction, and I'd like to thank Craig Safety for inviting me to speak here today. As Carrie indicated, most of my practice is involved with the transportation and logistics industry, and primarily what I do is represent transportation entities in what I'll call casualty cases, which are cases involving claims of wrongful death and/or serious personal injury. For example, when there's a truck accident. As Carrie noted, the title of this presentation is "A Sword or a Shield: How Internal Corporate Policies Can Help or Hurt Transportation Companies in Litigation." By way of background and why this topic is important to what I do, more often than not, given how the industry has evolved over the years, I receive my casualty cases from an insurance company. And usually the cases come to me long after an accident has occurred and a lawsuit's been filed. It could be anywhere from 2 to 5 years prior to when I receive the case file. And more often than not, when you get to the written discovery process, the plaintiff's first request is for all drivers' handbooks, employee manuals, safety policies, etc. Now, sometimes these policies are prepared by a professional, but many times they're not. You know, companies will draft their own policies or what have you. And kind of the point that I want to bring out today is that poorly thought out or poorly drafted policies can have devastating effects to the defense of a casualty case for a trucking company. Now, what I'll call the problem policies that we're going to talk about today, they're by no means exclusive. I mean, you could talk for days about policy manuals and policy issues, but what I've tried to do is point out a number of policies that I often encounter in my work and explain why they become problematic in the litigation setting. Excuse me. Now, with that said, it's kind of set the stage. It's kind of helpful to look at a truck wreck case from the plaintiff's perspective, or more specifically, the plaintiff's lawyer's perspective. And in regard to these type of cases, the plaintiff at trial has to prove that the trucking company, lying through the acts of its driver or other employees, was somehow negligent. And to establish negligence, a plaintiff has to show that the trucking company owed a duty to the plaintiff. There was a breach of that duty, and the breach caused plaintiff's damages, caused the plaintiff to be harmed. Now, more often than not, the duty that a trucking company or any company owes to the general public is a duty of reasonable care. And these are somewhat vague terms, at least from the plaintiff's point of view. You know, they'll argue or tell you that the phrase reasonable care is so vague, it could mean anything. And to address these issues, the plaintiff's bars come up with at least a couple of litigation strategies that are kind of hot right now, and they're called the rules of the road and the reptile theory. Now, in regard to the rules of the road, the basic theory is from the plaintiff's point of view, it's their belief, or the plaintiff's bar's belief, that good liability cases are lost by injured plaintiffs because the evil defense attorney is somehow able to confuse the jury. And the confusion lies in kind of vague phrase or vague terms used in jury instructions such as reasonable care. They want to argue that again, that these phrases are so overused that they don't mean anything, and therefore it's fertile ground for confusion. So to combat this perceived confusion, plaintiff's counsel seeks to use statutes, regulations, and corporate policies as the measuring stick for reasonableness. In other words, if a driver violated a company policy, he must have been negligent. That's how they define reasonable care and the breach of that duty of care. You know, there's a rule out there and it's been breached, you trucking company are negligent. And you know, these theories are not unique to the trucking industry, but they're particularly effective against the trucking industry, given all the rules that are out there, the Federal Motor Carrier Safety Regulations, state statutes, and other law, and then, of course, company policies. Over the years, the rules of the road theory has kind of evolved into the reptile theory, which is really what's very popular right now with the plaintiff's bar. And as I've noted in the PowerPoint, this theory is kind of the rules of the road theory, but on steroids. And it's a strategy in which plaintiff's counsel attempts to shift the focus away from the accident, what happened out there on the road, and they want to shift the focus onto the company's behavior and what the company did or didn't do. And again, this is a very rule-based theory or strategy that plaintiffs employ. And what they attempt to do is show to the jury that a safety rule exists, and again, in the trucking company, or excuse me, the trucking context, there are all kinds of rules that pertain to safety. And then they want to establish or push home the point that the safety rule is designed to prevent danger. The violation of that safety rule can create a danger of injury or death, and that the defendant trucking company violated the safety rule, and that the defendant's violation increased the risk of injury or death, not to just the plaintiff, but to the community. The idea is not to consider the case before the jury based on the facts, but they want to go a step beyond and frighten the jury. And the idea, and whether scientifically any of this is accurate, what they're trying to get at is what they call the reptilian brain, and it's to trigger a flight or fright reaction by juries. And unfortunately, this theory's been extremely successful from the plaintiff's point of view, and the use of it has resulted in many extremely high jury verdicts in the transportation context. And I think a simple example of a safety rule that's often used would be, hours of service. The plaintiff's lawyer will show that there's a rule that exists restricting the number of hours a driver can drive on any given day or any given week. It's pretty easy to show that that rule is designed to prevent danger. Violation of that rule can create a situation where you have a fatigued driver. The defendant in any given case may have violated that rule, and whether or not fatigue caused the accident is almost wholly irrelevant. But then they'll go on and show that this violation increased or could have increased the risk of injury or death to the community, including the people in the jury box. So with that said, with the kind of a background as to how plaintiffs attempt to attack trucking companies in the context of casualty litigation, I'd like to move on and talk about some categories of what in this slide we call bad policies that can come back and invite companies in litigation. And the categories of policies include, as stated on this bullet, or the slide rather, policies that oversell or exaggerate, policies that can't or won't be followed, and then the third, which I think is the most interesting, which we'll get to in a bit, are policies that create a standard above and beyond the minimum that's required by the Federal Motor Carrier Safety Regulations and or state law. And then the last category are policies that inadvertently leave a negative impression of the trucking company in front of the judge and or jury. In regard to policies that exaggerate or oversell, these are policies that look good on paper, but for whatever reason they're not that effective. And I think that log auditing falls into this quite often. And just by way of a real life example, a number of years ago, I assisted Pat McMonigal in my office in the defense of a wrongful death case in which there were 5 fatalities. And the plaintiffs in that case alleged that our driver fell asleep, crossed a grassy median separating the east and westbound lanes of a major interstate highway, where it struck 2 vehicles and killed the 5 victims. The plaintiffs further claimed that the driver was fatigued and grossly over hours, which is, unfortunately, those are all fairly common allegations. Well, we, of course, in our investigation, requested the company's policies and copies of all the logs, supporting documents, etc. And the company policy looked great on paper. It was, we audit 100% of the logs all the time, no exception, period. And in fact, the company had won numerous safety awards from the State Trucking Association, and everything looked great. And we were wondering what was going on, what evidence did plaintiff have that our driver was over hours? When we dug, excuse me, I've got a frog in my throat. When we dug into the facts a little more in the documents, what we discovered was that the company did in fact audit logs, but the audit consisted of just throwing the logs in a scanning machine, which checked the math, and if the math was okay, the log passed. And there were very few logs that were actually audited by a human being, where the supporting documents and whatnot were actually compared to what the driver had written down. And it became really clear that that this company's drivers had learned to game the system. I mean, you'd look at these logs, and at the time the 10-hour rule was in effect, and all their drivers would log exactly 10 hours a day, exactly 15 minutes for every pre-trip, post-trip inspection, every break. They all traveled 650 miles in that 10 hours, which is impossible. I mean, the math adds up, but there's no way they averaged 65 miles an hour for 10 straight hours. But it was like that day after day after day. And then when you looked at this particular driver's logs, and again compared it with the supporting documentation and the cell phone records, it became clear that that he was in fact grossly over hours, and that case ended up settling for quite a bit of money. So log auditing is an issue that I often run into in my practice. The second policy that looks good on paper but can be problematic in litigation involves policies or what I'll call a safety standard proclamation that you'll find in many safety policies. And basically what I mean by this is when a driver's brought onto a company, he's often given copies of the driver manual, safety manual, etc. And there'll be flowery language from the president of the company or the safety director to the effect of, "Welcome to ABC Trucking. ABC Trucking strives to be the safest trucking company known to man." Okay, and that can be a problem if there's a wreck and a trucking company doesn't do anything more than what's required by the safety regulations. Again, if you're not going to actually take steps to be the safest company known to man, don't say you are. I mean, it makes for a very uncomfortable deposition of the safety director or the owner of the company. And as we'll discuss a little bit later, it can create a standard for the company that might not have otherwise existed. PowerPoint has decided not to work here, but move on for a moment. The next slide, if we can get there, is there we go. Second categories of policies that become problematic are just policies that flat out aren't followed by the company. And again, examples that I run into quite often are safety meeting requirements and then record retention. In regard to safety meeting requirements, it's very common for trucking companies to have policies requiring its drivers to come in, quarterly or a couple times a year for a safety meeting. But in my practice, that unfortunately almost never happens, and it's particularly unfortunate when the safety director will tell me, "Yeah, we had these 4 meetings last year, and driver John Doe, he was at all of them." And you talk to driver John Doe, and he's like, I've never heard of a safety meeting at this company. I've never been to one. Again, that's a situation that becomes very uncomfortable for me as a defense attorney, and it makes for problematic testimony in a deposition and in a trial. Another example that's common, like I indicated, is record retention. And record retention, particularly given the advent of electronic discovery, is a very hot topic. It has been for at least the last 5 years, and you could go to seminars lasting weeks on problems with record retention and electronic discovery. But with that, I will say that it is extremely important to have a record retention policy, including policies dealing with electronic discovery, such as emails, electronic logs if your company has e-logs, and other data that track motor carriers and freight. It's very important to have policies dealing for that information. It's equally or more important to follow those policies. And I'll just give one example of what can happen in a casualty type situation in which the trucking company's records were lost after an accident. And it's a case that emanated locally out of the federal court in downtown Kansas City, Missouri, called Garrett v. Albright. And this was also a multi-fatality case, which, for the record, I was not involved in. But the trucking company at issue claimed that it lost its driver's logs, the accident file, it lost the logbook audits, and satellite tracking information. Now, as a punishment, as a discovery sanction, the judge sanctioned the company $30,000, but more importantly, the judge struck the pleadings from of one of the companies involved, meaning that it could not offer a defense at trial. And then a second company involved in this case, the jury was instructed that it could assume that the lost information or data would have been favorable to the plaintiff. And not surprisingly, that resulted in a $15 million judgment by the jury, and the case ended up settling for $18 million while the jury was still deliberating on the issue of punitive damages. So again, it's critical to have record retention policies and to follow them. The third category, which I alluded to earlier, is the most interesting issue for me, at least from a legal standpoint, are policies that go above and beyond what is required by the Federal Motor Carrier Safety Regulations or state law. And as I'm sure everyone on this call knows, the Federal Motor Carrier Safety Regulations set forth minimum safety standards. And the regulations specifically state that trucking companies are able to enact policies that, again, go above and beyond that minimum. And for very legitimate reasons, business reasons, a company may want to go above and beyond the minimum and be more safe than what's required. And that's fine, but you need to go, if you're going to do that, you have to do it with open eyes, because there are some problems with doing so. And again, a simple example may be speed limit. A lot of companies have policies limiting their drivers to, let's say, 65 miles per hour, where in a number of states, drivers can go faster than that. Well, the issue becomes what happens if there's an accident and that driver was traveling in accordance with the posted speed limit, but was in violation of company policy. Should that company be punished for trying to do better than what's required? And there's case law that says yes. And these are two examples that I'll talk about in a little more detail. The Commonwealth v. Angelo case and Marks v. Mobil Oil. And the Angelo case is a Massachusetts case in state court, or was in state court in Massachusetts. And it was a criminal case. And it's interesting in that the trucking company was charged with homicide by motor vehicle after its employee truck driver struck and killed a police officer in a backing accident. And basically the facts of this case were there was a construction project on a roadway outside of a mall, I think in suburban Boston, and the driver for the defendant trucking company was delivering asphalt to the construction site, as were a number of other trucks. And there was a experienced veteran police officer at the scene who was there to help direct traffic through this construction site. Upon arriving at the site, the company driver stopped his truck, got in line, had a conversation with the police officer about what order people were to deliver their asphalt, and thought everything was fine. Before moving, the company driver told the police officer that he was about to back up. He rolled down his window, checked his mirrors, turned off his radio, and began to back very slowly. So far, so good. It doesn't sound like anything the driver did was wrong. Certainly, he was in compliance with state law. The problem was the trucking company had a policy, and it was a policy concerning backup alarms. It required each of its trucks to be equipped with an operational backup alarm, which again wasn't required by Massachusetts law. And you know, for obvious reasons, the company had very legitimate business reasons for having such a policy. Unfortunately, on this truck, the backup alarm was inoperable. The driver knew it, the company knew it, they just hadn't done anything to fix it. And the company ended up being convicted. That conviction was reversed on appeal, but then it was affirmed or brought back when the case got to the Massachusetts Supreme Court. And the Supreme Court stated that an employee's violation of his employer's rules intended to protect the safety of third persons is evidence of the employee's negligence for which the employer may be held liable. So again, this company was punished for having a safety policy or rule that was above and beyond the minimum. In Marks versus Mobil Oil, this was a federal court case, and I won't go into as much detail, but it had a similar type result. The plaintiff was the father of a young man who was very seriously injured in an accident, and it was a passing accident. And the plaintiff claimed that a mobile truck passing a passenger car in which his son was operating created an air current or a bow wave during the passing maneuver, which forced the passenger car off the road, resulting in the injuries. And one of the allegations was that Mobil was negligent because its driver didn't honk its horn before passing to let the plaintiff's son know that this truck was in the process of passing. Excuse me. Again, honking the horn certainly wasn't required by state or local law, not required by the Federal Motor Carrier Safety Regulations, but the Mobile Driver Handbook contained a provision that its drivers had to honk when passing. And the court found this was enough to sustain a finding of negligence, holding that the rules embody the company's definition of proper driving practices, and the jury is entitled to consider such rules in making its determination as to whether the defendant was negligent. Again, if you want to go back to the rules of the road or the reptile theory, the phrase reasonable care and breach of reasonable care is now replaced by the company's policy, which is a lot more clear. The truck driver didn't honk. God only knows if not honking had anything to do with the accident, but that was enough for a finding of negligence against this particular company. And again, Mobil Oil was in effect punished for doing more than the bare minimum. So again, you may want to, you have legitimate business reasons to be better than the minimum, but do it knowing that it can come back and bite you. These, the next category involve policies that place the trucking company in a bad light. And you know, I often see these in cases in which, you know, it's a small company and you know, the company's owner or safety director drafted policies on his or her own. And sometimes, you know, there's no ill intent or ill will, but after an accident, they sure look bad, okay? And it's always a plaintiff's favorite theme of a case that trucking companies, you know, are big, bad, and evil, and they're just out to make money, and that profit is more important than the safety of the motoring more important than the safety of the motoring public. And kind of a surprise policy where this becomes an issue is progressive discipline. And by that I mean, very often a company will have a policy where it assigns points for violations that a driver may have. And it may be, you know, a driver can accumulate 12 points in a year, and if he does that, he's fired. Well, this is a real-life example. I had a case where the company assessed 2 points against its drivers for speeding or for a log violation, but 5 points for a late delivery. Well, that's not much of a stretch for the plaintiff's lawyer to argue that this company doesn't care about safety. It just wants to make sure that its cargo is delivered timely so it can make money. A second category that falls under this slide are post-accident policies. And very often, these policies are meant to be an instruction manual for a driver after an accident. And unfortunately, a lot of these policies seem to imply that the trucking or the driver should make sure the company's equipment and cargo is okay before checking on personal injuries to see if the other car and the other folks are okay. Again, that's tough to defend in a litigation setting. And then, you know, the policies that require drivers to contact the company after an accident and not to talk to anybody, including law enforcement. Again, there may be perfectly good reasons why a company doesn't want its driver that's had an accident out there talking to everybody at an accident scene. But again, be aware that that in front of a jury it doesn't look good when the policy says, you know, John Doe, the driver, was specifically instructed by this company not to talk to the police. What does that mean? And then lets the jury run with that. That can be unfortunate. We do have a little time, and I wanted to shift gears just a little bit before we go to questions. Everything I've talked about thus far has more or less dealt with casualty and personal injury litigation. And with that said, again, a hot topic regarding company policies involve employment issues, which again you could talk about all day long. But I just wanted to give you just a little flavor of what's going on in the employment context, so that, because I don't want to leave the impression that when you draw up company policies or have somebody else do it, that you can only consider safety and casualty. In EEOC versus Old Dominion Freight Lines, that's a case that was tried this past January in Federal District Court in Arkansas. And the basic facts of that were Old Dominion had a driver that self-reported an alcohol problem. Old Dominion, I think very prudently, had a policy. In their case, it was an unwritten policy, but a policy nonetheless, that anybody that reports an alcohol problem or is an alcoholic will never be returned to a driving position. Okay? They don't want to be in a situation where they knowingly put an alcoholic, recovered or otherwise, on the road. That person goes on a bender and then goes out and kills a bunch of people. That's, from a casualty point of view, a very prudent decision. Well, the Equal Employment Opportunity Commission disagreed and filed suit against Old Dominion under the Americans with Disabilities Act, claiming that a policy that, without exception, requires that drivers with alcohol problems be terminated is in violation of federal employment law. And as I indicated, that case went all the way to trial, and a jury verdict of $100,000 plus was rendered against Old Dominion. So again, in addition to the safety issues, there are a whole host of employment issues that have to be considered, which we'll leave for another day. And with that, I think we probably have some questions, Gary.
Well, if you have some questions that you would like to ask John, go ahead and put those in using the chat feature. Go ahead and write those in right now, and we'll try to field some of those. So I don't have anybody quite yet, but we'll give you a few minutes to see if somebody does have a question. I think the basic thing is that when you do write a policy, it's so important to write it and follow it to the very max, because if you don't, then of course, like John said, then they can see that you were lacking, and that opens up another opportunity for risk. So we'll go ahead and see if we get any questions.
While we're waiting, just by way of conclusion, I think some of these are obvious. It's important to make promises not to make promises that you can't or you won't keep. Avoid, absolutes when possible. Pay attention to what you say as well as what you do when creating policies for your company. I think, as we've talked about in some detail here today, use caution when you're creating standards above and beyond what's required by the safety regulations or other law. Retain a professional, so you're not in a situation where you're trying to justify policies that you wrote, and then investigate and implement a comprehensive system for creating and carrying out whatever policies you deem appropriate for your company.
And I'd say one other one that I don't see here, or maybe it's incorporated, but document, document, document. Keep those documents in writing. Keep everything that you have so that you can show proof that you have followed through, that you have taken the necessary steps, so that when you do go to court, you have the documentation to take with you, and they're not trying to take somebody's word, because I don't think word always does a lot in court. It doesn't stand very tall.
Very often doesn't. Well, seeing no questions, I think we can wrap up, and I appreciate everybody's participation in this this webinar, and if you do have any follow-ups, I believe my email address is in the slides.
We will be posting this to our website, so there will be, and then we'll be doing an email afterwards for everybody as well. So you can go back and look and see what the email addresses are. Also, if you have topics that you would like to have more information on, or perhaps have a webinar on, we would appreciate you sharing those topics with us. So are there things you're finding that confuse you or have given you problems in the past? We would like to be able to see what those are and try and find an answer. So that's all I have today. I just want to thank John for his time and coming in and talking about policies. They're always very tricky. The biggest trick of all is following the policies that you set and making sure you document and making sure you set reasonable policies. So thank you, John. Thank everybody that's come in. And if you have any questions that we can help you with, I hope that you'll contact me, Carrie Simmons, or you'll contact us through our website and send in those ideas or questions that you might have, and we'll see how we can help you. You all have a good day, and thank you again for joining us, and check back and join us again.